Ladies and gentlemen, lend me your ears and your eyes. Diva Divine Light, live from Brooklyn, New York.
With no delaying for what you saying, yo. Said it with my 9 million with the dilly, yo. When I be on the mic, yes, I do my duty, yo. While up in the club, I be while in the studio. You don't wanna violate, nigga, really and truly, yo. My main thug nigga named Julio, he moody, yo. Like a nigga that'll slap me with the tulio. Bitch, nigga scared to death, act fruity, yo. Fuck that, look at shorty, she a little cutie, yo. The way you shake it, make you wanna get all in the booty, yo. With no delaying for what you saying, yo.
Diva Divine Light.
Really my heart to me. Fuck me, see what you got for me. Put more than years with my eyes to see. Stop $1 in a place to be. If you really my heart to me. Fuck me, see what you got for me. Put more than years with my eyes to see. Stop $1 in a place to be. If you.
You're watching Diva, the Divine Light. A fun-loving, caring, passionate person who talks about sex, celebrity, and real-life issues, and even abuse. So hit that like button and make sure you share the show.
Really my heart to me. Fuck me, see what you got for me. Put more than years with my eyes to see. Stop $1 in a place to be. If you really my heart to me. Fuck me, see what you got for me. Put more than years with my eyes to see. Stop $1 in a place to be. If you really my heart to me. Fuck me, see what you got for me. Put more than years with my eyes to see. Stop $1 in a place to be. If you really my heart to me. Fuck me, see what you got for me. Put more than years with my eyes to see. Stop $1 in a place to be. If you.
Here comes the pitch, and it comes in wide. On the combo.
Yo. What's going on, guys? I'm back. Yes, I'm back. What's up, guys? Hey, Jacqueline. What's up, Tears? Indigo. Fat Boy. Hey, Karen J. My girls are in the building. What's up, ladies? And my boy. Well, I know that there's a lot going on right now, so it is what it is. We're going to just get to reading, and that's what it is. There's a hot mess going on over there. It's a lot of stuff. You know, I don't know how these people are so much in denial of the paperwork that's out there. I mean, they're like, oh, it's just writing on paper. None of it is fact. What are you talking about? Videos and pictures? Where's that at? Where's that at? Show me. Well, we've been showing you for a very long time. I don't understand why y'all still don't get it. It was proven in court. Point blank, period. Hey, T-Bam. Right, Tears. Like, what the hell? What's up, Aisha? Like, what is going on? How do you people not stick to the paperwork and what's going on and pay attention? They're all just trying to cover up for R. Kelly. This is what people have been doing for the past 30 years. They're still doing it today. It is what it is. R. Kelly's going to be found guilty again. He's going to be denied on these attempts, and he's going to have to take it to the Supreme Court, right? Okay. So, yeah, I'm going to find out exactly what the steps are, because I believe if she denies it, then she goes to the Second Circuit. And then if they deny it in the Second Circuit Court, then I believe they go to the Supreme Court. I'm not sure. Don't quote me on that, but I believe that that's the process. Hey, Nicole. What's up, mama? R. Kelly's a dog head. What's up, baby? Right. The defense didn't dispute that. The defense actually said, listen, there were still pictures of R. Kelly engaging in sex with the boy and the girl. They were having a threesome and they were videotaping it and they took pictures. Bon Jean said that herself. She saw it with her own two eyes. And she's like, but that doesn't mean anything. But that doesn't mean anything. That didn't prove anything. What did it prove? What? She's doing what she got to do to try to do something for the guy. I mean, he paid her, right? Unless she's pro bono. Who knows? I don't know. So, let's go into the government's response, okay, to the motion that Bon Jean had put in yesterday, which is what we read, which was the 12-page document for the Rule 33, the Motion 33 for a new trial. So here goes the government. The government's doing an introduction, and they say the defendant seeks a new trial pursuant to Rule 33 of Federal Rules of Criminal Procedure. As a result of his conviction on September 27, 2021, of 9 counts, charging racketeering and multiple violations of the Mann Act. In his motion and supporting memorandum, the defendant argues that he, 1, was denied effective assistance of counsel because his trial attorneys failed to conduct a meaningful voir dire of potential jurors and challenge unqualified jurors, and 2, was denied conflict-free counsel under the Sixth Amendment because one of his attorneys simultaneously represented the victim who testified at trial under the pseudonym Jane. For the reasons set forth below, the court should deny the motion in its entirety. So the government's like, we need to deny this. He's not getting a new trial. We're not going to go for the whole thing of dropping and acquitting him. This is not happening. Then they go into the parts of applicable law. And it says that the Rule 33 provides that the court may grant a defendant's motion for a new trial if the interest of justice so requires under the Federal Rule Criminal Law P33A. However, motions for a new trial are disfavored in this circuit, and the standard for granting such a motion is strict. And then they cite a case law, and in that case law, they recite it because accordingly, courts must exercise their Rule 33 authority sparingly and only in the most extraordinary circumstances. And then they cite another case law. And then it goes to the defendant was not denied effective assistance of counsel during voir dire. So now this is the government's argument. And they're saying he was not denied that. And it says that the defendant asserts that he is entitled to a new trial where his trial team conducted no meaningful voir dire and acquiesced to the seating of jurors who were unqualified to serve on this jury. This claim lacks all merit. Then they're going to go into the relevant background. And the government proceeds to say that in order to facilitate jury selection in this case, approximately 575 prospective jurors completed a comprehensive 28-page questionnaire comprised of 108 questions. And that was docket number 115. The court then invited the parties to submit challenges to any prospective jurors based on the questionnaire responses. The parties thereafter submitted a joint list of 251 prospective jurors they agreed should be stricken for cause. So they took out 250 prospective jurors that they agreed that should be stricken for cause, and they did that. Then it shows in dockets number 152, 157. Then they continue to say that in addition to the agreed upon 4 cause challenges, the government submitted a list of 34 additional prospective jurors it challenged for cause for various reasons. And the defendant submitted a list of 145 additional prospective jurors he challenged for cause for various reasons. The court then directed the remaining prospective jurors who were not challenged for cause by either party based on their questionnaires to appear for an in-person voir dire. Now, over the course of 2 days, the court conducted in-person voir dire in 2 phases. During the first phase, the court addressed the prospective jurors in a group setting, advising them of multiple principles of law, including the burden of proof, the defendant's presumption of innocence, and the need to follow the court's instructions. During the second phase, the court spoke with the remaining prospective jurors individually, outside the presence of the other prospective jurors, making further inquiries of each prospective juror, including posing additional follow-up questions submitted by the parties in writing and orally during voir dire. During in-person voir dire, the court excluded approximately 34 prospective jurors for cause for various reasons. So including scheduling conflicts, English comprehension issues, financial hardship, and concerns about the prospective jurors' impartiality. So after voir dire was complete, the parties exercised their preemptory challenges from the pool of qualified prospective jurors, and the court subsequently seated and swore 12 jurors and 5 alternate jurors to hear the case. Following the close of evidence and the court's final instructions, the 12 jurors deliberated, ultimately finding the defendant guilty on all 9 counts in the third superseding indictment. With respect to count 1, which charged the defendant with racketeering, the jury found that all racketeering acts, except racketeering acts 3 and 4, had been proven by the government. None of the alternate jurors was called on to deliberate. So none of the alternate jurors were called on to deliberate. It was the original 12. Now they're going to go into legal standard. Okay, yeah. Now we're going to go to legal standard. A defendant who attacks his convictions based on claims of ineffective assistance of counsel must, 1, show that counsel's performance fell below an objective standard of reasonableness under prevailing professional norms, and 2, affirmatively prove prejudice. Example, demonstrate that there is a reasonable probability that, but for counsel's unprofessional errors, the results of the proceeding would have been different. And then they cited case law. And under the case law, under the Strickland standard, a petitioner must establish both, 1, that counsel made errors so serious that defendant was deprived of reasonable, competent representation, and 2, that counsel's deficient performance prejudiced the defense. Me and that word, that one word, it gets me. Apologize about my mispronunciation. Both prongs must be satisfied to succeed on an ineffective assistance claim, and the court need not address both components if a defendant fails to establish either one. So as a failure on either showing in dispositive, Strickland, and then, okay. Then they're going to talk about deficient performance. So with respect to the first prong, a defendant must identify the acts or omissions of counsel that are alleged not to have been the result of reasonable professional judgment. So the court must then determine whether, in light of all the circumstances, the identified acts or omissions were outside the wide range of professionally competent assistance. Then it says that judicial scrutiny of counsel's performance must be highly differential, and strategic choices made after thorough investigation of law and facts relevant to plausible options are virtually unchallengeable. Then they cite another law, and it says that under that law, that the actions or omissions by counsel that might be considered sound trial strategy do not constitute ineffective assistance. Ooh! Ooh! Go one, government, go one! That's a good one. I'm glad you found Henry versus Pohl. Thank you for that. Did you guys understood what I just said? Did you guys understand that sentence? Actions or omissions by counsel that might be considered sound trial strategy do not constitute ineffective assistance. What do you guys understand what that said? Kelsey is all right, guys. Okay, Nicole. So what that means is if his defense team, right, decided to use that action or omission by the counsel to strategize to go for an appeal, right? Right? Or strategize to have him acquitted, or strategizing to keep Nicole on, right? Even though we know she was an ineffective counsel because there was a conflict and all that, yada, yada, right? So if his team used that as some type of strategy, that's not good. That means that that trial strategy does not constitute as ineffective counsel, guys. So it doesn't matter. So, okay. Strategic choices made after thorough investigation of law and facts relevant to plausible options are virtually unchallengeable, honey. You can't challenge that. There's no challenging this. None. According to the law. Bojo. Good luck, Bojo. Mm-hmm. So let's get that straight. Okay. Did I understand that? Did you guys understand what I read? I hope y'all understood. Those in the back, those watching on the replay, those in the chat. Then it says, moreover, evaluating counsel's performance must not serve as an opportunity to act as a Monday morning quarterback. This isn't the Super Bowls, baby. We ain't scoring on this one. There ain't no score, girl. Okay, then they cite some more law. And in this law of Senkowski, they're saying that a court must not use the words, must not use, quote unquote, they say, perfect hindsight to criticize unsuccessful strategies. 2020 hindsight, baby. You look a little cross-eyed. This ain't working. This strategy ain't working, baby. Then it cites another law. And under this law, it talks about how finding that the performance inquiry examines the reasonableness of counsel's actions under all circumstances, keeping in mind that a fair assessment of attorney performance requires that every effort be made to eliminate the distorting effects of hindsight. So, if you've seen all of this crap happening in hindsight, 2020 vision, you needed to eliminate the distorting effects. Okay? So if you already knew that all this drama was popping off and all this was going on, you should have been handled that. Then it cites another quote from a law, and it says that rather, quote unquote, I'm going to quote now, a court must indulge a strong presumption that counsel's conduct falls within the wide range of reasonable professional assistance. That is, the defendant must overcome the presumption that, under the circumstances, the challenged action might be considered sound strategy. The Second Circuit has defined a strategic decision as a conscious, reasonably informed decision made by an attorney with an eye to benefiting his client. Well, Greenberg didn't have the eye, or he was just really slow. So it cites another law, and within that little law there, they talk about internal citation and quotation marks are omitted. Now, when examining an ineffective assistance claim in the context of jury selection, consistent with Strickland, which is the law, right? A case that happened, and in that case, there was laws that were cited. An attorney's action in conducting voir dire are also afforded difference. They cite another case law stating that holding that trial counsel's decision not to seek an alternate juror is paradigmatically strategic. Indeed, courts are loath to second-guess the decisions of counsel during jury selection. And they cite some more laws. Then they say that strategies as to the exercise of preemptories are matters of counsel's intuition and do not rise to the level of constitutional violation. Got it? So, strategies as to the exercise, preemptories are matters of counsel's intuition. It's a matter of them making decisions upon their intuition. Is this guy going to be good, or is this girl going to be good? I don't know about that one, or I don't know about that one because they said this and they said that, but I don't know. Could they really be? It's all based on intuition. And because it's based on intuition that these lawyers must pick these jurors, this does not rise to the level of a constitutional violation. They're just doing their job. These people fill out the questionnaires. They go with the flow. They go with their gut. They say, that's the guy that's going to help us out. That's the guy that's going to be on our side. I don't know about him, but he's whatever. But his mind could be changed. It's all based on tuition. And that, as far as the lawyers picking the jurors, that is not a level of constitutional violation. It is not the role of the court to second guess counsel's reasonable strategic decisions at jury selection, especially considering that counsel is strongly presumed to have rendered adequate assistance and made all significant decisions in the exercise of reasonable professional judgment. Then it states that an attorney's actions under another law, an attorney's actions during voir dire are considered to be a matter of trial strategy and cannot form the basis for an ineffective assistance claim unless counsel's tactical decisions are so ill chosen that they permeate the entire trial with obvious unfairness. And it was only a couple, it's not all. So there was no unfairness. Then it says, additionally, if a defendant fails to demonstrate that he requested that his attorney exercise a preemptory challenge for particular jurors, the petitioner is deemed to have acquiesced to the attorney's decision not to do so. So the defendant has, if he fails to demonstrate that he requested that his attorney exercise these challenges for these jurors, the petitioner is deemed to have acquiesced to the attorney's decision not to do so. So R. Kelly can make the judgment, the call on, listen, I don't know, I think you should take that guy out, or ask him again this question, or, you know, he has that. But it's not his deemed decision to do so. Now, the petitioner says that petitioner has failed in this other law, says that petitioner has failed to demonstrate he requested trial counsel exercise any challenges as to the jurors, and as such, petitioner is deemed to have acquiesced in trial counsel's decision not to do so. Then it says that holding the defendant's acquiesced of acquiescence of trial counsel's strategic decision amounted to forfeit of defendant's right to assert constitutional infirmities. Hold on one second, guys. Sorry about that, guys. My apologies. Let me continue. Okay. All right. I'm going to say hello to everybody who walked into the building. Hello, James. What's up, James? Rocking with the truth. Aisha. Take our Kelly. What's up, mama? Spiritual gangsta. What's up, mamita? Who else is in here? Tasha. What's up, baby? Granny. What's up, Granny? All right, let's see. Anybody else walked in the building? T-Bam, what's up, T-Bam? Truth Strong Warrior. What's up, baby? Noonie! My Noonie made it. Noonie, you made it, mama. I'm going to drop the link. I'm going to drop the link. What's up, guys? I'm going to drop the link. I'm glad I went into the chat. I would have missed all of y'all. I'm glad I took a pause for a second. Let me put the link in, guys. Give me a moment. Okay. I dropped the link, y'all. She said my cousin's still talking. You got company, baby? Okay, so let me continue here. All right. Okay. So now we're on the second part where it talks about prejudice. It says, with respect to the second prong, an error by counsel, even if professionally unreasonable, does not warrant setting aside the judgment of a criminal proceeding if the error had no effect on the judgment. Then it cites another case law, and it says that under this, thus, to establish prejudice under Strickland, the defendant must show that there is a reasonable probability that, but for counsel's unprofessional errors, the results of the proceedings would have been different. A reasonable probability is a probability sufficient to undermine confidence in the outcome. A court must review the prejudicial effect of counsel's errors in the aggregate. I got you right now. My Noonie.
Yo.
What's up, chula?
Hey.
Hi, baby. Are you ready?
Yes.
You want to read with me, mama?
Mm-hmm.
All right. Can you see good on the screen?
Yeah.
All right, cool. So I'm going to finish this one page and then you can go on to the next, okay?
All right.
All right. Here we go. Let me go back to the paperwork. Okay, so a court must review the prejudicial effect of counsel's error in the aggregate, and then it says another case law, and then it says, moreover, unlike the determination of trial counsel's performance under the first prong of Strickland, the determination of prejudice may be made with the benefit of hindsight. Then it says, to establish prejudice stemming from trial counsel's failure to challenge a prospective juror for cause during voir dire, a defendant must establish actual bias. Then it says another case law, but however, to maintain a claim of ineffective assistance of counsel based on the failure to object to a biased juror, the petitioner must show that the juror was actually biased against him. So now Bojo has to prove that these jurors were actually biased against R. Kelly. Then it says, based on the lack of actual presumed bias of the jurors, the petitioner has not. And Noonie, you can take it from there. Noonie, mama, you there?
Okay.
Ready?
So where significantly?
Right here, mama, where it says demonstrated that he was prejudiced.
Demonstrated that he was prejudiced by his counsel's failure to strike these jurors and has therefore failed to establish ineffective assistance of counsel. Actual bias is bias in fact, the existence of a state of mind that leads to an interference, that the person will not act with entire impartiality. Do you want me to read all that too, or just?
No, just go straight to the words right here.
Okay. Actual bias can be found where a prospective juror admits partiality and where the same can be inferred from his or her answers to voir dire questions. Significantly, even where a juror expressly doubts his or her impartiality on voir dire, a finding of actual bias is not automatically mandated. Holding the ambiguous and contradictory testimony of 3 jurors was inefficient to overcome presumption or of correctness owed to trial court's findings that the jurors would be impartial. The test of determining juror bias is well established. To hold that the mere existence of any preconceived notion as the guilt or innocence of an accused without more is sufficient to rebut the presumption of a prospective juror's impartiality would be to establish an impossible standard. It is sufficient if the juror can lay aside his impression or opinion and render a verdict based on the evidence presented in court.
Exactly.
Mm-hmm.
It is conceived that determining the juror's bias, you can't. He's got to go off the evidence. He can't just go over
their feelings.
Right, his mere notion. You know what I mean? He has to go by the presentation of what the government presented, what the defense rebutted, and all the evidence that the accuser has against him. That's it. And it is sufficient if the juror can lay aside his impression or opinion and render a fair verdict. It can happen. Go ahead, Nuni. Start from right here, Mama. Oops, sorry. Right here.
Even where a juror is previously expressed some reservations about his ability to be fair and impartial, if the juror later expresses during voir dire that he will try to decide the case based on the evidence presented, the assurance is generally sufficient. Therefore, to prevail a claim that defense counsel was ineffective in failing to remove or challenge a juror during voir dire, a defendant must show that the juror was actually biased against him.
Right. Yeah, Mama.
Without a finding that the juror was actually biased against petitioner, prejudice under Strickland is not presumed.
Okay.
Analysis. The defendant's ineffective assistance claims are wholly without merit. He cannot establish either prong under Strickland, and his motion should be denied. The defendant first makes one generalized assertions that trial counsel failed to conduct any meaningful voir dire of prospective jurors to ensure they were free of bias or prejudice. Unfounded and vague claims that trial counsel should have, for example.
Right here, Mama. Probe more deeply.
Okay. Probe more deeply. Mem 7 inquired further at 9 or completely questioned. Mem at 12, certain jurors. These claims are wholly
belied by the court.
Okay, got that, you moved it. Belied by the record, which shows that the trial counsel actively participated throughout the voir dire process, submitting additional questions and asserting challenges for cause, both in writing and orally, in some cases successfully as to various prospective jurors, including those prospective jurors who impartially may have been in question. In addition to the defendant's written for cause challenges with respect to approximately 50 prospective jurors initially qualified after the first 2 days of in-person voir dire. The defendant questioned that the court make further inquiries of approximately 19 prospective jurors, including additional questions related to the prospective jurors, opinions on the Me Too movement, and related topics, as well as their knowledge of the defendant and the nature of the charges. Okay. On various occasions, after hearing certain prospective jurors' responses to the follow-up questions, trial counsel could not challenge them. However, with respect to certain other prospective jurors, defense counsel challenged, and the court ultimately excused the prospective jurors for cause based on their response to inquiries related to the Me Too movement. Trial counsel inquiries on these topics clearly reflect that they considered the very issues now raised to the defendant by the defendant when making cause and preemptory challenges, and made strategic decisions in certain instances not to challenge a particular. Oh my God, what's wrong with me today? Okay, not to challenge a particular prospective jurors based on their responses to inquiries from the court and the parties. Reasoning that affects that trials counsel's decision not to challenge a juror for cause was strategic may be evidence by trials counsel used for cause challenges on the prospective jurors. Finding that counsel's active participation in voir dire indicates that any decisions to challenge or to not challenge jurors were made as a part of a reasonable trial strategy, rather than a result of counsel's failure to provide effective assistance. Rejecting ineffective assistance of counsel, claiming regarding voir dire because the record reflected the defense counsel was actively engaged in the voir dire process, and attorney's determination to accept or strike a prospective juror was a strategic and tactical decision. Internal citation omitted. Finding that counsel's decision to preemptorily challenge 8 jurors lent support to conclusions that the decision not to challenge allegedly biased jurors was part of a trial strategy. Counsel exercised 2 preemptory challenges for other prospective jurors during the voir dire. This suggests that counsel deliberately chose not to challenge other juror as part of the trial strategy that might be considered sound. Do you want me to read the last part too? Eva, you're mute. Okay. Nor the defendant shown that he suffered any prejudice. He provides no tangible evidence of actual bias, relying only on speculation based on the challenged jurors' responses during voir dire as purported evidence of bias. Finding jurors were not actually biased against petitioner, and therefore he was not prejudiced by trial counsel's failure to challenge them, where petitioner offered no evidence beyond the voir dire testimony of 3 individuals as to how the juror was biased, other than speculation regarding these jurors' ability to be impartial, given that each of the jurors at issue asserted their impartiality and that they could fairly decide the case. Indeed, the very fact that the defendant asserts that trial counsel should have uncovered some additional imaged information, but produces no actual information supporting the claimed bias. Emphasis, the speculative nature of these claims. In addition, the defendant's claims regarding trial counsel's failure to challenge prospective jurors who had some knowledge of the defendant and or the allegations against him, including through affirmative responses to question 31, indicating they had watched or heard interviews of Robert Kelly, TV shows featuring him, or specials or documentaries about him. Knew of the Me Too movement, also lacked merit, as the Supreme Court made clear. Qualified jurors need not be totally ignorant of the facts and issues involved in a case. Every case of public interest is almost as a matter of necessity brought to the attention of the intelligent people in the vicinity, and scarcely anyone can be found among those best fitted for jurors who has not read or heard of it, and who has some impression and some opinion in respect to its merits. Most cases, pretrial publicity even purveys adverse publicity does not inevitably lead to an unfair trial. Rejecting ineffective assistance claim, finding the defense counsel's decision to not challenge a juror was within the realm of sound trial strategy, and the defendant could not establish actual bias where the police officer juror advised he could have had personal knowledge of the facts of the case in his employment, but did not recall any such knowledge and could remain impartial. Further, the defendant's unsupported assertion that jurors' own subjective assurances that they could be fair was not sufficient to ensure they did not harbor beliefs or preconceived ideas about the defendant's guilt. Flies in the face of both the record and the binding legal precedent that it is sufficient if the juror can lay aside his impression or opinion and render a verdict based on evidence presented in court. As set forth in further trial below, the defendant has abjectly failed to prove that trial counsel did not act strategically in deciding not to challenge certain jurors for a cause or use preemptory strikes to prevent their selection. He also fails to show that any of these jurors bore actual bias against the defendant. He, therefore, cannot show deficient performance and prejudice. Juror number 3, formerly prospective juror number 25, the defendant asserts that trial counsel is ineffective in failing to challenge juror number 3, given his response that he had seen a documentary about the defendant and his legal troubles, and heard that he has been sleeping with underage girls. As noted above, the mere fact that a juror had knowledge regarding the defendant or aspects of charges does not automatically create presumption of bias, particularly whereas here the juror has indicated that he can set aside his prior knowledge and decide the case based solely on the evidence presented at trial. Indeed, the defendant completely ignores, as he does with each juror's affirmation and impartially, juror number 3, unequivocal statements both in response to the questionnaire and during in-person voir dire, which reflect a total lack of bias and clear ability to be impartial. For example, in response to question 31, juror number 3 advised that he had seen a documentary about the defendant, but added, "I don't know the full story, so I have no feelings about it. I remain impartial." Question 31, emphasis added. Moreover, in response to question 32, which asked whether he had an impression of the defendant based on what he had seen or heard, juror number 3 advised that his impression was neutral, adding that the media tends to demonize people. I deal with facts. Question 32, juror number 3 also advised that he had not overheard discussion about the case, nor had he discussed the case with anyone else or online. See question 33, 34, 35. Juror number 3 further responded that neither the defendant's celebrity nor anything about the nature of the case would interfere with his ability to decide the case fairly and impartially in accordance with the court's instructions. With respect to question regarding the so-called Me Too movement, juror number 3 indicated that he was aware that the movement seeks justice for rape victims 25 to 30 years after the fact, and also stated that he had not participated in the Me Too movement. See question 91-92. Juror number 3 also indicated that he had no reason to believe he could not apply the law, that the defendant is innocent until proven guilty, and the government bears the burden of proof. See question 65. During in-person voir dire, juror number 3 further affirmed his ability to be fair and impartial when asked whether there was any reason he could not follow the court's instructions regarding the burden of proof and the fact that the defendant was innocent until proven guilty. Juror number 3 responded, no reason at all, when he asked by the court whether there was any reason he could not be able to follow the court's instructions on the law. Juror number 3 responded, no, I am a stickler for the on my job. I'm the rule guy. Moreover, juror number 3 answered that there is no reason at all why he couldn't follow the court's instruction not to research the facts, law, or people involved in the case. And when asked by the court, is there any reason at all why you wouldn't be able to give both sides a fair trial? Juror number 3 again unequivocally answered no. In these circumstances, the defendant cannot show deficient performance of counsel's decision not to challenge juror number 3, and also fails to prove any actual bias on juror number 3, part that would be result in prejudice, failing both Strickland prongs.
You want me to read the next?
Whew, girl.
Yes, give you a break. Go ahead, Mama.
All right.
All right. Then it continues to say, indeed, it was clearly sound strategy on the part of trial counsel to not exercise a preemptory challenge. Juror number 3 explained in his questionnaire that he had been arrested on 2 occasions, which resulted in charges being dismissed. Question number 44. And during the colloquy, with the court empathetically expressed that he had previously had certain negative experiences with law enforcement, and that while he was not biased against law enforcement, he was biased against people in law enforcement that do these things. Thus, trial counsel likely made the strategic decision to keep juror number 3 because they believed the juror's past negative experiences with law enforcement, including being falsely arrested twice, coupled with his belief that the media demonizes people. Question number 32 would make him more critical of the government's case. Trial counsel may also have reasonably believed that the government might use preemptory strike on juror number 3. Given the government's follow-up questions, which trial counsel may have interpreted as concerned regarding juror number 3. On the part of the government, rejecting claim of ineffective assistance of counsel where defense counsel did not object during voir dire process because, among other possibilities, counsel among other reasons, failed to object so as to force the prosecution to expend an additional preemptory challenge to strike the juror. Juror number 4, formerly prospective juror number 52. The defendant next claims deficient performance due to trial counsel's failure to challenge juror number 4. Based on the juror's questionnaire that the juror finds transmission of STDs in a non-consensual act to be particularly repulsive, has a close friend who was a victim of sexual assault, and listed the person he least admired as Jeffrey Epstein. Again, the defendant fails to carry his burden to establish either Strickland prong. Juror number 4 questionnaire and voir dire responses in no way amount to actual bias against the defendant. A juror is not required to have entirely neutral feelings about the particular types of crimes charged. Denying post-conviction relief and finding trial counsel's decision not to challenge prospective juror in narcotics trial who expressed views about dangers of drug use given family history of drug abuse was not deficient performance, where juror affirmed ability to be fair and impartial after court advised juror that nobody is asking you to walk in here totally blank. You will bring in your life experiences, and that the relevant question was only whether juror could follow the laws as I give it to you, and will you be fair and impartial. Rather, the central issue is whether the juror can lay aside any preconceived notions. Here, juror number 4 indicated that he could. Nor was bias established on the ground that juror number 4 knew an individual who was a victim of sexual assault. Give me a second. I gotta regulate real quick. Okay, sorry about that, guys. So, nor was bias established on the ground that juror number 4 knew an individual who was a victim of sexual assault, notwithstanding that the charges against the defendant involved sexual assault. Finding that bias could not be inferred where juror advised the court that, among other things, his wife had been abused before they were married. In case involving prosecution of defendant for forced labor of two young girls, importantly, in response to question number 37, which asked whether there was anything about the nature of the charges in and of themselves that would prevent the juror from deciding the case fairly and impartially in accordance with the court's instructions. Juror number 4 responded, no. Question number 37. Likewise, in response to question 65, which asked if there was any reason why juror number 4 could not apply the law that the government bears the burden of proving the defendant guilty beyond a reasonable doubt on each charge, juror number 4 responded no. Question number 65. In fact, as was evident from juror number 4's questionnaire and in-person voir dire, juror number 4 had very little knowledge of who the defendant was, confusing the defendant's alias, R. Kelly, with the famous cartoonist from decades earlier. Even upon clarification, the defendant was not the cartoonist. Juror number 4 had very little knowledge of the defendant and had seen some news articles that did not appear to have made any impression on him. So when asked whether there was anything that juror number 4 had read that would affect his ability to be fair and impartial in the case, he responded, not that I know of. Moreover, when the court spoke of the duty of jurors to decide the case based on the evidence at trial, juror number 4 added that the case was to be decided by the evidence, testimony, and your instruction on the law, clearly demonstrating his understanding of his duty as a juror. When the court advised juror number 4 that the government bore the burden of proving the defendant guilty beyond a reasonable doubt, juror number 4 responded, right, and stated that he would have no problem following the court's instructions that the defendant is innocent until being proven guilty. Therefore, any potential concerns that may have arisen from juror number 4's questionnaire responses were alleviated by juror number 4's clear responses in the questionnaire and during voir dire, that he could remain fair and impartial and decide the case according to the court's instructions. In these circumstances, the defendant cannot show either deficient performance or actual bias, and his claim should be rejected. Denied. Juror number 5, formerly prospective juror 87. The defendant claims that trial counsel should have challenged juror number 5 because she had some knowledge of the defendant and had a somewhat negative impression of him. In response to why juror number 5 had this impression, juror number 5 wrote that there was an allegation that related he was sleeping with underage girls, minors. Question number 32. Notably, juror number 5 specifically used the word allegation to describe whatever knowledge she may have had about the case. Despite being aware of this allegation, which is no more than was included in the summary of the case provided as part of the juror questionnaire, juror number 5 advised that she had not overheard any discussion about the case, discussed the case with anyone, or posted any opinions online. Juror number 5 further responded that neither the defendant's celebrity nor anything about the nature of the case would interfere with her ability to decide the case fairly and impartially in accordance with the court's instructions. During the in-person colloquy, The Carlo guy, sorry for my mispronunciation. The court asked juror number 5 whether, despite having some familiarity with the case, juror number 5 was able to put aside anything that juror number 5 had heard about the case and just judge it on evidence that you hear in the courtroom. Juror number 5 responded yes. The court asked the second time, stating, okay, and put aside all those other things you might have heard. To which juror number 5 again stated yes. Shortly thereafter, the court asked juror number 5 whether there was any reason she could not follow the court's instruction that the defendant was innocent until proven guilty, and that the government has the burden of proving the defendant guilty beyond a reasonable doubt. Juror number 5 again responded no. In response to the court's inquiry as to whether the juror was hesitating a bit in her answer, juror number 5 stated no. There wouldn't be no reason that I wouldn't be able to. Where I work, you have to. Where I work, we have to follow the order. In response to the court's further questions regarding whether juror number 5 would follow this important principle of law regarding the burden of proof and would follow the court's instructions of law, juror number 5 said yes to both. During this portion of the questioning, juror number 5 initially responded, well, as you mentioned, according to when you listen, whatever you hear, so I think I'll give it a shot. As a result, a colloquy followed in which the court explained to juror number 5 that regardless of her answer, juror number 5 needed to be positive in that response. When asked if she was positive that she could give both sides a fair trial, juror number 5 said yes, that she could be positive in her belief that she would be fair and impartial. Importantly, juror number 5's use of the word think in her response to the court's questions does not demonstrate implied or actual bias. Finding no bias when juror replied, no, I don't think so, after being asked whether she might favor the prosecution's argument, their defense, their witnesses, because you are a member of their office, and confirmed that she could acquit the defendant if she found the prosecution had not proved its case. Finding juror had no actual or implied bias warranting relief, where when asked whether his experience as a police officer would carry over into petitioner's trial, the juror responded, well, sir, I would certainly like to be able to say that it wouldn't, and I would certainly do my best to see that it did not. Moreover, even if juror number 5's response demonstrated some initial ambiguity about her impartiality, she affirmatively stated that she could be fair and impartial upon further questioning. Trial counsel's decision, therefore, not to challenge her was not deficient. Rejecting claim of ineffective assistance of counsel based on trial counsel's decision not to make a four-cause challenge where juror expressed doubts about his ability to be fair and impartial given his employment as a police officer, but subsequently answered in the affirmative upon further questioning about whether he could base his decision in the case solely on what he would see and hear in the courtroom, and where there was no evidence in record that the court would have granted a challenge for cause even if defense counsel objected. Holding that decision not to challenge a juror for cause, when that juror expressed that she was sensitive to the issue, but ultimately stated that she would try to remain fair and impartial, did not amount to ineffective assistance of counsel, particularly where, based on the juror's response to a hypothetical question posed during voir dire, the attorney may have reasonably inferred that the juror would be sympathetic to defense strategy he planned to use at trial. Finding no actual bias where juror initially stated that he could try to be fair and impartial, and then subsequently agreed that he would leave sympathy and emotions out of his deliberations and decided from the facts on this witness stand. Concluding that district court did not err in failing to remove prospective juror for cause where juror initially expressed reservations about ability to be impartial but later promised to try to decide the case based on the evidence presented. Upholding the denial of challenge for cause where a juror indicated he would do his best to decide the case based on the evidence presented. The defendant thus cannot show deficient performance or actual bias and fails both Strickland prongs. Nuna, you still there?
Yes, I'm here.
All right. You ready to read a little bit?
Yeah.
Okay.
Oh, shit. Okay, where?
We're on number 4, Mama. Juror number 7.
Okay. Juror number 7, formerly prospective juror number 145, the defendant asserts the trial counsel was deficient in failing to challenge juror number 7 because she had heard certain information about the defendant's alleged crimes. The claim is based while juror number 7 advised that she was aware of who the defendant was and the existence of the case him. Juror number 7 stated that she had not seen any documentary about the defendant and that her impression of the defendant was neutral because most of the information you hear about celebrities are not always true. It's mainly either for or against the person. Questions 29 and 32. Juror number 7 also advised that she had not discussed the case with anyone or posted any opinions about the defendant online. Questions 33 and through 35, and made clear that she would remain fair and impartial in deciding the case, indicating that there was no reason she could not follow the court's instructions regarding the burden of proof. And the fact that the defendant is innocent until proven guilty. During the in-person voir dire, when asked whether she could put aside the very little she had heard about the case and rely only on the evidence in court, juror number 7 answered, sure. Moreover, when asked if she promised that she will be fair and impartial, jurors both sides, juror number 7 responded, of course. In these circumstances, the defendant cannot show actual bias and his ineffective assistance claim must fail. In addition, the defendant cannot show the trial's counsel's decision not to strike juror number 7 was not strategic. During the trial, defense counsel sought to emphasize the defendant's musical talents and popularity as a part of its trial strategy. Thus, trial counsel may have believed that juror number 7's knowledge of the defendant's music, see question 30, and her lack of the knowledge of the Me Too movement made juror number 7 an attractive juror. In any event, in the light of the juror's unequivocal responses establishing her impartiality, the defendant cannot show actual bias, or the court would have granted a motion to strike. Juror number 8, formerly prospective number 147. The defendant claims that the trial counsel cannot deficient in failing to challenge juror number 8 because he had heard about the crimes that the defendant allegedly committed. Notwithstanding such knowledge, juror number 7 advised that he had a neutral impression of the defendant, that he had no feeling toward the defendant. question 32, in response to the other questions, juror number 7 made clear that he would judge the facts of the case fairly and impartially in accordance with the court's instructions. During in-person voir dire, juror number 8 also answered each of the court's questions in an unequivocal manner consistent with his ability to put aside anything he knew about the case, hold the government in its burden to prove the defendant guilty beyond a reasonable doubt, and the judge it fairly and impartially. In these circumstances, the defendant cannot show actual bias, nor can the defendant show the trial counsel did not strike juror number 8 for the strategic reasons. In the questionnaire, juror number 8 advised that he listens to the defendant's music and has no views on the cases. Given juror number 8's other responses indicating that he had no knowledge of the Me Too movement and could not clearly be fair and impartial, trial counsel likely believed that juror number 8 was a fan of the defendant's music and thus would be a favorable juror for the defense. In any event, in light of jurors' unequivocal responses establishing his impartiality, the defendant cannot show actual bias, or the court would have granted a motion to strike. Juror number 9, the defendant claims the trial counsel was deficient in failing to challenge juror number 9 because she had heard of the defendant had unknown issues in the law and had knowledge of the Me Too movement. In response to questioning regarding whether juror number 8 was familiar with the defendant or any allegations against him, juror number 8 wrote, "Sounds familiar, but unsure." And the defendant had issues with the law before, but couldn't tell you exactly what for. Juror 9 also indicated that she had a neutral impression of the defendant because I know he's arrested before, but don't know if he was convicted or not. I don't watch entertainment news or follow gossip influencer sites about celebrities. In response to question concerning knowledge about the Me Too movement, juror number 9 described the movement of the power structure of the male-dominated movie industry that had been turned on its head and indicated that she had not participated in the Me Too movement. In response to the other questions in the questionnaire, juror number 9 made clear that she would judge the facts in the case fairly and impartially in accordance with the court's instructions. During in-person voir dire, the court asked juror number 9 whether she could put aside any prior knowledge that she may have had about the case and decided it only on the evidence presented in court. To which juror number 9 responded, "Yes, I can." In response to questions regarding whether juror number 9 promised to follow the court's instructions on the burden of proof, the defendant's presumption of innocence, the law, and refraining from obtaining outside information about the case, juror number 9, as she did in the questionnaire, answered an affirmative to all, promising to do her duty as a fair and impartial juror. The defendant has offered no evidence to suggest the trial's counsel decision not to strike juror number 9 was anything but strategic, as an individual had a neutral view of the defendant, did not follow gossip sites about the celebrities, and who had a relative who was convicted of a federal crime and served 5 years in prison. Trial counsel likely believed that juror number 9 would be a favorable juror to the defense. In these circumstances, the defense cannot show actual bias, and deficient performance of his ineffective assistance claim fails. In any event, in the light of jurors' unequivocal responses establishing her impartiality, the defendant cannot show the court would have granted a motion to strike. Juror number 11, the defendant claims the trial was deficient in failing to challenge the juror number 11 because she had heard and read about the alleged crimes on the news. Specifically in response to questions regarding whether juror number 11 was familiar with
Hold on.
the defendant or any allegations against him, juror number 11 wrote that she saw the cases mentioned on the news when the defendant was first being investigated, knew that the defendant is a musician and that there were allegations of misconduct lodged against him. Juror number 11 also indicated that she had neutral impression of the defendant because I do not know enough information about the defendant or the case. In response to other questions in the questionnaire, juror number 11 made clear that she would judge the facts of the case fairly and impartially in accordance with the court's instructions. Similarly, during in-person voir dire, when asked by the court whether she could put aside any prior knowledge that she may have had about the case and decide it only on the evidence presented in court, juror number 11 responded yes. In response to questions regarding whether juror number 11 promised to follow the court's instructions on the burden of proof, the defendant's presumption of innocence, the law, and refraining from obtaining outside information about the case, juror number 11 answered in the affirmative to all, promising to do her duty as a fair and impartial juror. In these circumstances, the defendant cannot show actual bias or deficient performance.
You want me to go or you want to continue?
It doesn't matter. I don't mind.
Okay, go ahead, Mama.
Okay. Juror number 12. The defendant claims that the trial counsel was deficient in failing to challenge juror number 12 because he had heard about the crimes that the defendant allegedly committed from various sources and had knowledge of the Me Too movement. While juror number 12 indicated that his somewhat negative impression of the defendant resulted of an emotional response to the nature of the charges against the defendant, juror number 12 was also advised in that same response that he really never cared one way or another regarding the defendant. In response to the other questions in the questionnaire, juror number 12 made clear that he would judge the facts of the case fairly and impartially in accordance with court's instructions. During in-person voir dire, when the court raised the fact that juror number 12 had indicated on the questionnaire that he had some information about the case, juror number 12 advised the court that it was just minor things in the press. Nothing, can't recall any specific details. Juror number 12 added that, in fact, the summary and questions included in the questionnaire provided more information about the nature of the case than what he had previously been aware of through any media coverage. When asked whether he could put the information aside and judge the case based on the evidence presented in court, juror number 12 responded, "Of course," stating it most definitely is when the court referenced juror number 12's statement in the questionnaire that trial by media is worse than trial by jury. Subsequently, in response to the questions by the court regarding whether juror number 11 promised to follow the court's instructions on the burden of proof, the defendant's presumption to follow the court's instructions of the burden of proof and the defendant's presumption of innocence, juror number 11 responded 100%. Further, with respect to the court's inquiries about whether he could follow the law as the court instructed and refrain from obtaining outside information about the case, juror number 11 answered in affirmative, promising to do his duty as a fair and impartial juror. The record thus clearly reflects that there was no actual bias on the part of juror number 12. Trial counsel's conduct with respect to this juror was also not deficient under Strickland. First, counsel had a strategic reason not to strike this juror. In the questionnaire, juror number 12 advised that he had a friend who was related to Bill Cosby. And as a part of his discussion of his opinion of Bill Cosby's sexual assault, both of the questionnaire and during voir dire indicated that until the end of the case, I have no opinion, adding that trial by media is scarier to me than a jury. Juror number 12's position regarding Bill Cosby's case only case not only reflected by his ability to keep an open mind unless and until he had all the facts, but also likely formed a bias of trial counsel's strategic decision not to strike the juror number 12, given the nature of Bill Cosby's allegations. In addition, juror number 12 had a family member who was sentenced to 10 years in prison. A reasonable attorney could certainly have believed juror number 12 would be a favorable juror for the defense, notwithstanding his somewhat negative view of the defendant and knowledge of the Me Too movement. For this reason, in any event, in light of the juror's unequivocal responses establishing his impartiality, any for-cause challenge would have been futile.
Yeah, futile.
Okay. Alternative. Okay.
All right. I'll take over for a couple of pages. All right. Number 9. Alternate juror number 4. Formerly prospective juror number 179. Finally, the defendant claims that trial counsel was deficient for not challenging alternate juror number 4 as a result of her knowledge that the defendant was married to Aaliyah. And as he characterizes it, for making an untimely challenge to alternate juror number 4 during trial, for asking the court's clerk whether the clerk could obtain an autograph from attorney Gloria Allred, who represented certain of the witnesses at the trial on her behalf. Even assuming arguendo, the alternate juror number 4 should have been dismissed, notwithstanding the court's proper determination on the matter, given that this alternate juror did not deliberate and thereby had no impact on the verdict. The defendant cannot show prejudice from her selection as an alternate. More important, however, appellant cannot demonstrate that he was prejudiced by the trial judge's refusal to excuse this veneer person for cause, since prospective juror was never a member of the jury that convicted the defendant. So that juror she was complaining about wasn't even, they dismissed her. Bonjean, you wasn't reading all that stuff. She wasn't reading all that stuff. It was her clerks and stuff. They're the ones who did all that filing for her. Moreover, as the defendant concedes, trial counsel did, in fact, seek alternate juror number 4's dismissal. As such, the defendant cannot show that trial counsel engaged in deficient performance under Strickland. Finally, as reflected in the record and set forth in the great detail in the government response to the defendant's motion for a judgment of acquittal, docket number 278, which is incorporated herein by reference, the evidence against the defendant on all charges was overwhelmingly, and the defendant has presented no evidence to demonstrate that the jury's verdict was based on anything other than the evidence presented at trial. Holding the defendant's ineffective assistance of counsel claim that trial counsel's failure to strike juror, who was allegedly equivocal as to whether she could hold the prosecution to its burden and allegedly evinced a state of mind like to preclude her from rendering an impartial verdict, lacked merit, finding that In the absence of bias, petitioner cannot satisfy the second prong of Strickland because there is no basis to conclude that. Had the juror not been seated as a juror, the results of petitioner's trial would have been different. Accordingly, the defendants claim that trial counsel provided ineffective assistance of counsel during voir dire should be denied. Denied. The defendant was not denied conflict-free counsel. Then they're going to talk about the relevant background. Pursuant to its obligations under the United States versus Curcio, the government brought certain issues to the attention of the court regarding potential conflicts held by one of the defendant's retained attorneys, Nicole Blank Becker. The potential conflicts raised by the government were set forth in detail in sealed written submissions dated June 14th of 2021. The sealed June 14th, 2021 letter and June 24, 2021, the sealed June 24, 2021 letter, collectively referred to herein as the sealed letters, and incorporated herein by reference. Docket number 107 and 114. The defendant bases his motion on one of these issues, specifically regarding the possibility that Ms. Blank Becker entered into an attorney-client relationship with certain individuals, including an individual referred to in the sealed letters as Jane Doe number 5, and herein as Jane. Sealed June 24, 2021 letter, docket number 114. Another issue, also relevant to the assistant motion, sealed to individual identified at trial as Joy or Joycelyn, and is detailed in the sealed letters. Following the government's filing of its Curcio hearing, the court appointed independent counsel to advise the defendant on the issues, and on June 17, 2021, the court conducted a Curcio hearing, which was further adjourned to allow the defendant ample time to confer with independent counsel. On July 15, 2021, the court continued the Curcio hearing to determine whether conflicts existed and whether the conflicts were waivable by the defendant. In making its determination, the court relied upon written submissions and exhibits by the government. Ms. Blank Becker and Ms. Gloria Schmidt Rodriguez, who formerly represented Jane, as well as proffers in information by the government. Ms. Blank Becker and Ms. Gloria Schmidt Rodriguez. Based on this information, the court determined that potential or actual conflicts existed with respect to the issues raised by the government, but that all of the raised conflicts, including those related to Jane, could be waived by the defendant. Based on its findings, the court advised the defendant of each of the conflicts and the relevant implications of those conflicts. During the hearing, the court also advised the defendant that he had the right to conflict-free representation, but under the circumstances could waive the conflicts if he so choose. Relevant to the instant motion, the court advised, among other things, that Ms. Blank Becker may have developed a relationship of trust with certain individuals, including Jane and Joycelyn, even though she were never formally retained as their lawyer. She has confidentiality obligations to them. And given the nature and extent of those communications and the content of them, she would have a conflict if she were to cross-examine either one of them. So that's one of the conflicts. The court also advised the defendant that Ms. Blankbecker could not rely on or share with the defendant or his other attorneys any privileged information she may have obtained from these individuals. Also relevant to the instant motion, the court advised the defendant of the implications of a possible conflict related to an allegation regarding Joycelyn set forth in the sealed 14/2021 letter at pages 1 through 2, noting that there was not much of a foundation for the allegation. While the court did not make a specific findings as to whether Ms. Blankbecker had committed an ethical violation by contacting Jane while she was represented by Ms. Rodriguez, the court also advised the defendant regarding the implications of such a violation as it related to Ms. Blankbecker's representation of the defendant. The defendant advised that he understood all of the conflicts. Independent counsel also advised the court, and the defendant confirmed that she had thoroughly explained and discussed with the defendant each of the issues that was the subject of a cursio hearing. Subsequently, the defendant, at the court's request, explained his understanding of each of the conflicts on record, as explained to him by the court and cursio counselor. Notably, the court also advised the defendant that he had two lawyers who were not conflicted, Devereux Canick and Thomas Farinella, but that if he waived the conflicts, the defendant would be giving up the right to have Ms. Becker represent the defendant without a conflict of interest. And that means that if the defendant were to be convicted at a trial, the defendant couldn't later claim that the defendant's lawyer, Ms. Becker, wasn't an effective lawyer because she had these conflicts or potential conflicts. Like I said the last time when I read the cursio, it specifically said he cannot come back later to appeal and complain about a conflict of interest due to this lawyer. She let him know, you're waiving your right. Do you understand that? He said yes. She said, okay, are you sure? He said yes. She said, are you positive? The lawyer that I just pointed for you in this hearing, she's going to explain it to you again. I want to make sure that you understand the words that are coming out of my mouth. So she told his lawyer, the cursio lawyer that was there for him, please advise him of what this means and make sure that he understands before he gives me a definite answer. I'll give you a couple of seconds to the side to go talk to him. And he said, yes, I understand. Don't worry about it. When asked if he understood both these implications, the defendant responded, yes, I do, Your Honor. The defendant advised the court that he waived the conflicts and would continue with Ms. Blankbecker as one of his retained attorneys. At the conclusion of the colloquy with the defendant, the court found that it had established that Mr. Kelly is fully competent and capable of making an informed decision, that he has been advised by independent counsel, and that his waiver of this potential conflicts is knowing and intelligent, and so I accept the waiver. At trial, the defendant was represented by 4 retained attorneys, Mr. Canick, Ms. Becker, Mr. Farinella, Mr. Scholar. During trial, Jane testified. During the government's case in chief, and Mr. Canick conducted the cross-examination of Jane. The Sixth Amendment right to effective assistance of counsel generally ensures that An accused may be represented by any attorney who will agree to take his case. A defendant has a correlative right to representation that is free from conflicts of interest. When a defendant's right to choose the counsel he wants conflicts with the right to an attorney of undivided loyalty, the choice as to which right is to take precedence must generally be left to the defendant. District courts have an independent duty to ensure that criminal defendant sorry about that. That criminal defendants receive a trial that is fair and does not contravene the Sixth Amendment. For that reason, when a district court is sufficiently apprised of even the possibility of a conflict of interest, as the court was here, it has a threshold. Excuse me, guys. It has a threshold obligation to investigate the facts and details of the attorney's interest to determine whether the attorney, in fact, suffers from an actual conflict, a potential conflict, or no genuine conflict at all. So, where defense counsel has an actual or potential conflict, the district court must determine whether the conflict is so severe as to require the attorney's disqualification or whether it is a lesser conflict that can be waived in a crucial hearing. In most cases where a defendant's attorney has a conflict, the defendant may make a knowing and intelligent waiver of his right to a conflict-free lawyer if he desires to continue the representation. In only rare cases, an attorney's conflict is unwaivable because it is so serious that no rational defendant would have knowingly and intelligently desired the conflicted attorney's representation, or because the conflict is so severe as to indicate per se that the rendering of effective assistance will be impeded. Indeed, the Second Circuit has recognized only two categories of such per se violations of the Sixth Amendment. Noonie, can you do me a favor and take over this page real quick? I got to use the restroom if you're there. Or if not, I'll just put it on pause. All right. I got to go to the restroom, guys. Give me a second. All right, guys, I'm back. Sorry about that, y'all. Had to take a quick minute, you know. All right. So what I'm going to do is, for the last couple of pages, I'm going to let the reader read it, okay?
X. 2D Sir 1983, United States v.
Sorry,
Cunningham,
guys.
672 F.2D 1064, 1072-73, 2D Sir 1982. Moreover, in representing a current client, a lawyer may not ethically attack other clients through cross-examination or argument to the jury. See, example Raman, 861 F sub at 277. 32. Representation. Curcio, 680 F.2D at 881-91, Levy, 25 F.3D at 153. The Second Circuit has considered a number of different factors in determining whether a conflict can be waived, including, among other things, 1. Whether disqualifying the defendant's chosen counsel would create real prejudice to the defendant based on the length of the representation and/or counsel's familiarity with the case, Cunningham, 672 F.2D at 1071. 2. Whether there is a possibility that the attorney could be called as a witness at the defendant's trial or implicated in the defendant's alleged crimes, ID at 1075. 3. Whether the continued representation would conflict with the attorney's own personal financial or liberty interests, as opposed to the interests of a current or former client. United States v. Jones, 381 F.3d 114, 12021. 2D Sir 2004, Swartz, 283 F.3d at 96, Fulton, 5 F.3d 608. 4. Whether, if the conflict concerns the interests of another client, the attorney's relationship with the other client is continuing or has been terminated. Swartz, 283 F.3d at 96, Perez, 325 F.3d at 127. 5. Whether any other current or former client affected by the conflict has initiated or joined in the motion to disqualify defendant's chosen counsel. Cunningham, 672 F.2d at 1072, and 6. The availability of measures that might limit the dangers posed by the conflict, such as restricting an attorney's cross-examination of a former client. Cunningham, 672 F.2d at 1073. A defendant challenging his conviction on the ground that he was deprived of his Sixth Amendment right to effective assistance of counsel as the result of a conflict must demonstrate, first, that the conflict was either unwaivable or that his waiver was not knowing and intelligent. See Swartz, 283 F.3d at 95, and second, that he was prejudiced by the conflict. See Levy, 25 F.3d at 152, in other words, that but for counsel's unprofessional errors, the result of the proceeding would have been different. Fulton, 5 F.3d at 609, quotation marks omitted. Where a potential conflict exists, courts require that the defendant establish prejudice. ID 33.
Uh-oh. Something happened, guys. Give me a second. Uh-oh. Something happened, y'all. Give me a second.
Representation. Cursio, 680 F.2d at 881 to 91, Levy, 25 F.3d at 153. The Second Circuit has considered a number of different factors in determining whether a conflict can be waived, including, among other things, 1. Whether disqualifying the defendant's chosen counsel would create real prejudice to the defendant based on the length of the representation and/or counsel's familiarity with the case, Cunningham, 672 F.2d at 1071. 2. Whether there is a possibility that the attorney could be called as a witness at the defendant's trial or implicated in the defendant's alleged crimes, ID at 1075. 3. Whether the continued representation would conflict with the attorney's own personal financial or liberty interests, as opposed to the interests of a current or former client, United States v. Jones, 381 F.3d 114, 12,021. 2D Sir 2004, Swartz, 283 F.3d at 96, Fulton, 5 F.3d 608. 4. Whether, if the conflict concerns the interests of another client, the attorney's relationship with the other client is continuing or has been terminated, Swartz, 283 F.3d at 96, Perez, 325 F.3d at 127. 5. Whether any other current or former client affected by the conflict has initiated or joined in the motion to disqualify defendant's chosen counsel, Cunningham, 672 F.2d at 1072, and 6. The availability of measures that might limit the dangers posed by the conflict, such as restricting an attorney's cross-examination of a former client, Cunningham, 672 F.2d at 1073. A defendant challenging his conviction on the ground that he was deprived of his Sixth Amendment right to effective assistance of counsel as the result of a conflict must demonstrate, first, that the conflict was either unwaivable or that his waiver was not knowing and intelligent, see Swartz, 283 F.3d at 95, and second, that he was prejudiced by the conflict, see Levy, 25 F.3d at 152, in other words, that but for counsel's unprofessional errors, the result of the proceeding would have been different. Fulton, 5 F.3d at 609, quotation marks omitted. Where a potential conflict exists, courts require that the defendant establish prejudice. ID 33. Where an actual conflict exists, however, prejudice is presumed and the defendant is required to show only that a lapse in representation resulted from the conflict. United States v. Iorizzo, 786 F.2d 52, 58, 2d Sir 1986, quotation marks omitted. A lapse in representation means that some plausible alternative defense strategy or tactic might have been pursued, and that the alternative defense was inherently in conflict with or not undertaken due to the attorney's other loyalties or interests. Levy, 25 F.3d at 157, quotation marks omitted. In evaluating an actual or potential conflict of interest, while actions of any member of a law firm are imputed to every member of the firm, such conflicts are not imputed on independent trial counsel. See, example United States v. Stein, 410 F sub 2d 316, 329, SDNY 2006, Anwar v. United States, 648 F sub 820, 827, NDNY 1986. See analysis. The defendant alleges that he was denied effective counsel because Ms. Becker purportedly labored under a disabling conflict of interest that was imputed to the entire defense team. MEM at 13. The defendant's argument is meritless. It is based on incorrect claims that this conflict was unwaivable and imputed to the entire defense team, which included 3 other independent counsel from different firms who represented him at trial. During the Curcio hearing, the court determined that Ms. Becker may have developed a relationship of trust with Jane and Jocelyn, resulting in certain possible conflicts, including creating, among other obligations, a duty of loyalty to them. Cursio tr 32. Assuming that Ms. Becker's relationship with Jane amounted to an actual conflict, said conflict was clearly waivable. Several factors demonstrate that the conflict was waivable, including that, 1. The relationship was brief, limited in scope and terminated prior to Jane's. 34. Cooperation with the government, 15. 2. The relationship did not implicate Ms. Becker's own personal financial or liberty interests, and 3. The defendant was represented by 3 other unconflicted retained counsel who could and one of whom in fact did cross-examine Jane. During trial, C. Stein, 410 F sub 2d, at 328, listing factors weighing in favor of finding a waivable conflict, internal citations omitted. The defendant has proffered no facts from which it could be concluded that Ms. Becker's potential conflict amounted to an actual conflict of interest, nor do any of the cases cited by the defendant support the notion that Ms. Becker's conflict was not waivable. Point 16. Instead, the defendant incorrectly conflates the issue of whether an actual conflict exists with the question of whether the defendant may waive said conflict. As discussed above, it is well established that an actual conflict is not synonymous with an unwaivable conflict. See example United States v. Arrington, 941 F.3d 24, 42, 2d Sir 2019, but even though the second 15 the defendant's claim that Jane may have obtained privileged information from Becker that was adverse to the defendant, MEM at 17, completely misconstrues the government's representations on this point, and the assertion that Jane most certainly passed information subject to attorney-client privilege between Ms. Becker and the defendant, ID, is not only speculative, but patently false. Likewise, there is no basis to suggest, as the defendant does, that Ms. Becker's interactions with Jane, even if they amounted to an attorney-client relationship, were an attempt to influence a government witness on behalf of her client, MEM at 16. 16 Notably, the cases cited by the defendant support only the principle that counsel's representation of both the defendant and a witness generally creates an actual conflict, not that such conflict is unwaivable. In fact, the cases cited by the defendant demonstrate quite the opposite. See MEM at 18, citing United States v. John, 140 F3D 124, 128-29, 2D Sir 1998, noting that similar conflict may have been waivable and remanding case for determination as to whether a conflict in fact existed. United States v. Doggerdosh, 735 F sub 2D 113, 117-18. SDNY 2010, noting that one party refused to waive the conflict and disqualifying counsel because his law firm sought to simultaneously represent a defendant and a cooperating witness with adverse interests in the same criminal proceeding, Anwar, 648 F sub at 828, holding that petitioner has failed to allege facts supporting a conclusion that any of the potential areas of conflict arising when an attorney has previously represented an important witness for the prosecution existed in this case. 35. Conflict was actual, it was also waivable. Citing Perez, 325 F.3d at 125. Indeed, it is the rare exception where an actual conflict cannot be waived by the defendant, and even if the conflict here was actual, it does not constitute one of those rare instances. Rather, the conflict represents one of the lesser conflicts, such as an attorney's representation of 2 or more defendants or his prior representation of a trial witness that is generally waivable. Perez, 325 F.3d at 127, 12,829. holding that a defendant was entitled to waive a conflict created by his counsel's prior representation of another defendant despite assertions that counsel was blinded by his own substantial self-interest, and finding that counsel had nothing approaching the sort of fiscal self-interest that was present in Swartz, considering that there was no indication that counsel had a continuing relationship with, or an exceptionally lucrative retainer from, the other defendant. See also Stein, 410 F sub 2d at 329, holding that conflicts arising from trial counsel's prior representation of witnesses were waivable given defendants' willingness to continue with current counsel despite their being barred from cross-examining counsel's former clients at trial, and the defendant's consent to measures that might limit the dangers posed by conflicts, such as current counsel agreeing not to discuss his former clients with any independent attorneys hired to cross-examine them on conflicted counsel's behalf. Arrington, 941 F.3d at 41, although counsel's conflict compromised his ability to be a zealous advocate for the defendant, it was nonetheless waivable. We have generally found that this type of conflict is waivable. Internal citations omitted. In addition, any conflict related to Ms. Becker's conflict arising from any assumed attorney-client relationship with Jane was not imputed to the defendant's other counsel. The defendant's reliance on United States v. Stein in support of its claim to the contrary is misplaced. While Stein held that counsel's conflict was imputed to the other attorneys in 36. Counsel's small firm, independent counsel had no such conflict. See Stein, 410 F sub 2d at 329, holding attorney's conflict from prior representation of trial witness waivable because, among other things, independent attorneys could be hired to cross-examine those witnesses on conflicted counsel's behalf. Ms. Becker is a solo practitioner and the defendant's other counsel each have their own independent practices. Thus Messrs. Canick, Farinella, and Scholar were not members of any firm with Ms. Becker and remained unconflicted. See, example Anwar, 648 F sub at 827, finding that conflict was not imputed to co-counsel given that the record did not indicate a general partnership relationship between the attorneys extending beyond the representation of petitioner himself. Given that Mr. Canick, one of the defendant's three independent, unconflicted counsel, conducted a vigorous cross-examination of Jane at trial, the defendant has not shown that a lapse in representation resulted from the conflict. Iorizzo, 786 F.2d at 58, even assuming the circumstances presented an actual conflict. Nor can the defendant demonstrate that he was prejudiced in any way by Ms. Becker's conflict if it was only a potential conflict. There can also be no question that the defendant was fully advised of the implications and consequences of the conflict related to Ms. Becker's purported representation of Jane. After being so advised, the defendant knowingly and intentionally waived the conflict and chose to keep Ms. Becker as one of his attorneys. While Ms. Becker's conflict prevented her from cross-examining Jane at trial, and from disclosing any privileged information obtained, if any, from Jane to the defendant or the defendant's other counsel, the defendant was advised of those consequences, Cursio tr at 46, and was well within his constitutional rights to choose to continue to retain Ms. Becker. See, example Arrington, 941 F.3d at 42, a reasonable defendant may decide to retain a trusted attorney, even 37. At the risk of losing those advantages, after being properly informed of the risks and benefits of the consequences of that decision. Finally, with respect to the defendant's claim that Ms. Becker suffered from a conflict under Fulton, MEM at 16, the defendant is wrong. Again, the defendant conflates two separate issues addressed by the court during the Cursio hearing. As set forth in the June 14, 2021 sealed letter, in an abundance of caution, the government expeditiously alerted the court to speculative information it had received from the defendant's former attorneys related to Jocelyn and Ms. Becker. CECFDKT entry number 107, at 1-2, ECFDKT entry number 114, at 2-3, and 2 and 3. Jocelyn did not make any such allegations, nor did the government intend to or ultimately call Jocelyn as a witness at trial, CID, thus even if there existed the possibility of a conflict under Fulton, no conflict was likely to or did, in fact, arise. None of the dangers outlined in Fulton, therefore, existed here. See Fulton, 5F.3d at 613, noting that the allegations were by a witness who was testifying against the defendant at trial, making it a different order of magnitude from other conflicts. Moreover, in the unlikely event that Jocelyn was to be called as a witness at trial by the government at the time, as set forth in Fulton, the per se rule advocated by the defendant applies only where the alleged criminal conduct is true, or of the nature that it should be treated as true, not where the allegation is false. ID at 611. Therefore, in order to prevail on this claim, the defendant must show prejudice. Given the lack of evidence before the court regarding the alleged conduct, see Cursio TR at 38, there was no basis to treat the allegation as true. 17 CID at 613, stating that the considerations relating to the per se unwaivable conflict found in 17. In any event, even if the allegations were deemed to be true, Jocelyn was not called as a witness at trial. 38. Fulton do not apply if the allegations are clearly false. Thus, if a district court holds a full hearing and can definitively rule out the possibility that the allegations are true, a meaningful waiver is possible since the falsely accused attorney is conflicted only to the extent that she cannot cross-examine the witness regarding the false allegations. As discussed above, the defendant had 3 other independent retained counsel, including Mr. Canick, who acted as lead attorney at trial and could have cross-examined Jocelyn if she had been called as a witness. The defendant therefore has not and cannot provide any evidence that an actual conflict existed or, that, if a potential or actual conflict did exist, that a lapse in representation resulted from, or that he was prejudiced in any way by, the conflict. 18. Accordingly, this court should deny the defendant's motion in its entirety. 18. To the extent the defendant's reference to misconduct implicating a so-called Fulton conflict, MEM at 16, also concerns the potential ethical violation by Ms. Becker for contacting Jane and Jocelyn while they were represented by counsel, such a violation would not be the type of crime or misconduct sufficiently related to the crimes with which the defendant was charged as contemplated in Fulton. See Fulton, 5F.3d at 610. Of course, the per se rule does not apply any time a court learns that an attorney may have committed a crime. The attorney's alleged criminal activity must be sufficiently related to the charged crimes to create a real possibility that the attorney's vigorous defense of his client will be compromised. 39. Conclusion. Based on the foregoing, the defendant's motion for a new trial should be denied. Respectfully submitted, Brian Peace, United States Attorney. By /S/Elizabeth Geddes Nadia Shieta Maria Cruz Melendez Assistant U.S. Attorney 718-254.
Motion shall be denied. The motion should be denied. The government said the motion shall be denied. Everything that goes in should be denied. Well, guys, that was the end of that. Now we are waiting for the rebuttal from the defense. And they have until April 4th, I believe, to come up with their rebuttal. And then after that, we should be hearing from the judge. So from now until April 4th, guys, until then, please make sure you guys hit that like button. You already know, if you're not subscribed to the channel, please subscribe to the channel. Hit the notification bell, put it on all. Thank you very much. For those who are watching the replay all the way to the end of the video, please comment below in the comment section of the video. Thank you very much. If you are not a member of my members only crew, please join. It's only $1.99. I do exclusive things. You get perks. You get to put little emojis in the chat. Have fun with them. And just to let you guys know, Diva loves ya. I'm out. Peace.